Hello, everyone. Greetings from Rabat in the Kingdom of Morocco. The topic of today's webinar, part of the webinar series Addressing Global Environmental Challenges, is a global instrument for the governance of the Earth's freshwater, ? Before saying a very brief words on the substance, I first want to briefly introduce the Commission. The Work Commission on Environmental Law of IUCN is one of the 7 commissions of IUCN. It is a global network of more than 1,300 environmental law and policy experts from all the regions in the world. WCL works to enhance the development and strengthen the implementation of environmental law and policy, including through best practices and intersectoral strategies for effective compliance and enforcement. The Commission is led by Professor Christina Voigt and the International Steering Committee. The substantive work is by and large undertaken through 8 specialist groups and 4 task forces. One of those specialist groups, the Water and Wetlands Specialist Group, is a key convener of today's event, and I'm delighted to see the leadership of the group leading this event through Stefano and Mike, as well as the engagement of Robin, of course. Back to the topic of today, I wanted to help set the frame by referring fairly superficially to 7 elements that I believe will help address the question at the center of the webinar. First, in terms of data, to help drive the sense of urgency, a study that came out earlier this month, an abrupt decline in global terrestrial water storage and its relationship with sea level change, indicated that global terrestrial water storage, excluding ice sheets and glaciers, declined rapidly between May 2014 and May 2016. By 2023, it had not yet recovered. Second, looking at some reference points within the work of IUCN, I think it is important to keep in mind inter alia some recent elements. The resolution on the aquatic biodiversity conservation of shallow marine and freshwater systems, the resolution on the cooperation on transboundary freshwaters to ensure ecosystem conservation, climate resilience, and sustainable development, and of course, Nature 2030, IUCN Program 2021-2024, that clearly identifies vision that by 2030, freshwater systems support and should support and sustain biodiversity and human needs. The Union further indicated that it will contribute to the vision by aiming to achieve 3 impact targets, and I would like to say a few words about the third of those impact targets, which is that water governance, law, and investment decisions address the multiple values of nature and incorporate biodiversity knowledge. Third, I wanted to refer, of course, to the Brasilia Declaration of Judges on Water Justice. That declaration, inter alia, recognized the need for water laws to progress and not regress. Fourth, I want to refer to the Ministerial Declaration on Water for Shared Prosperity that was adopted as a key outcome a few months ago of the 10th World Water Forum in Bali. Fifth, I would like to invite you to consult the Pact for the Future, which was adopted a few months ago at UNHQ in New York, and that lists several actions, some of which are quite relevant for the discussion of today. Sixth, I wanted to highlight the opportunity of the IUCN World Conservation Congress next year in October in Abu Dhabi that can help drive forward the important agenda that we'll be discussing today. And seventh, as I am speaking to you from Morocco, a water-stressed country that is currently going through its 6th consecutive year of drought, of course, I'm particularly sensitive to the issue of fresh water. At the Hassan II International Center for Environmental Training, the academic arm of the Mohammed VI Foundation for Environmental Protection, chaired by Her Royal Highness Princess Al Hasna, we focus on ESG, education for sustainable development for, by, and around the environment through a lifelong learning approach. For example, a week before the official start of COP29, we hosted in partnership with UNDP the National Conference on Adaptation. Speaking of COP29, I would like to also invite you to consider the Baku Declaration on Water for Climate Action, which was adopted just days ago. In conclusion, I want to refer to a quote from Hermann Hesse's Siddhartha, quote, "They both listened silently to the water, which to them was not just water, but the voice of life, the voice of being, the voice of perpetual becoming," end of quote. Water speaks, let us listen. And a good place to start doing just that is by listening to the amazing array of experts that will be speaking during today's webinar. Having said that, and without further ado, I'm particularly happy to give the floor to the next speaker, who not only holds the volume of fresh water you can find in a large and deep lake when it comes to his knowledge on the issue that we're discussing, but also represents both co-organizers of this activity as chair of the IUCN WCL Water and Wetlands Law Specialist Group and chair emeritus of the International Association for Water Law. Dear Stefano Boschi, the virtual floor is yours. Thank you.
Thank you very much, Ayman. Thank you for your kind words of introduction. Welcome to everybody on behalf of the International Association for Water Law, of which I'm Chair Emeritus. The International Association for Water Law, which is referred to and better known as AIDA from its Spanish acronym, is a private non-profit international organization comprised of lawyers specialized in water law and of non-lawyers directly involved in the management and in various disciplines of water resources. The association was founded in Washington, D.C. in 1967, so it's been around for nearly 60 years. It has a current membership of about 70 members globally, mostly lawyers, but also, as I said, non-lawyers, engineers, administrators, academics, and specialists in water resources in one field of knowledge or another. The purpose of the association is to foster the evolution, study, knowledge, understanding, and application of water law, national and international, with a view to raising awareness and the knowledge and practice in this particular field of the law of natural resources. I would encourage you to visit the recently renovated website of AIDA at www.aida-waterlaw.org and maybe consider joining the association. Thank you very much for being with us today, and I give the floor to Michael Handke Domas for the introduction to this webinar. Thank you.
Thank you, Stefano, and thank you, Ayman. Well, it's a pleasure to be today with you. Well, as you know, this webinar is part of a series called The Transformative Powers of Law Addressing Global Environmental Challenges under the auspices of the World Commission of Environmental Law and the International Association for Water Law. My name is Michael Handke Domas, and I'm the Deputy Chair of the Water and Wetlands Law Specialist Group and an Associate Professor in Environmental Law at the Universidad San Sebastián in Chile. And today we will present the work we have been developing to propose a set of modern legal principles for the governance of fresh water with a view to a declaration eventually to be issued by the IUCN Future Congress. So today we have very substantial presentations. I must warn you that we slightly changed the order of the presentation. So we are going to have two separate panels. The first one is going to be led by Saki Schubert, seconded by Stefano Berchi, and myself at the end of that presentation. We're going to have a time for Q&A, and then we are going to have the second panel, which is going to be led by Ms. Jessica Curl and Ms. Robin Stein. So today, those five speakers, we will be presenting on these substantial issues to be considered in the future declaration. We trust that with participants of this webinar, we will be able to enhance the work being done by many questions and suggestions. So we will going to start the first 20 of this webinar. We will going to start with Ms. Saki Schubert, and she's AIDA member, and the floor is yours, Saki.
Thank you very much, Mike. So I'm going to talk to you about three elements of this initiative: its rationale, purpose, and scope. So beginning with the rationale, we really have three drivers here. And the first one is the experience of the water lawyers in this panel. And before I go any further, I want to acknowledge both Jessica and Stefano's contributions to kicking off this process. And so it's the experience of us and other water lawyers in national water legislation in countries around the world that made us come up with a number of realizations about domestic water law. There's a great variety of content for different reasons, differing legal regimes, the history of the development of that legislation, and other factors. And what we see is that some key issues are addressed, but many are not. We also notice that important areas have been overlooked so far in many parts of the world, and you'll hear more about them shortly, whether water tenure, gender issues, or indigenous rights, and other issues as well. There have also been recent developments, such as the impact of climate change, and that has implications when it comes to the structure of legal frameworks. And finally, and you'll hear from Stefano about this in more detail, we noticed a lack of integration and coherence between different domestic legal instruments and policies that deal with water-related issues, directly or indirectly, whether water is the central issue or whether we're talking about sectors like agriculture, energy, mining, industrial uses, and so forth. And so all of these make water resources management more complicated and maybe not as successful as it ought to be, and in some cases hinder progress towards achieving important water-related policy goals, such as the SDGs. Secondly, as many of you know, there are two universal conventions that deal with transboundary water cooperation and management and provide principles to guide states in their interactions. However, when it comes to domestic water legislation, there are no similar guidelines. There is, in reality, nothing that could help states to evaluate their legal framework and determine whether it is helping them to achieve their goals or not. We have comparative analyses, but not much else really. And so thirdly, we realized there's a need for principles and guidelines that could guide and inspire national legislation of countries to support the legal governance of freshwater resources management in the absence of conceptualization of such legislation for the time being. So the purpose of this initiative is twofold. It is, as I just said, to offer guidelines and frameworks, a framework for states to consider the national water legislation so that they can, firstly, assess the normative content of their existing legislation that deals directly or indirectly with water in light of the principles that are being developed and will be presented today, as well as others as the work progresses. What's presented today is not intended to be exhaustive. And then secondly, for states to have guidance on where to adjust or add to the content of their legislation when necessary. And so my final point is about the scope of this initiative. And as I just said, it's really to develop principles to provide broad normative guidance on national water legislation for states wishing to assess the current status of the laws and relating policies they have in place. And the aim here, this is an important point, is not to develop a multilateral convention on the matter, but rather to provide a guiding framework and to deposit these principles in a suitable vehicle, such as an IUCN resolution that has a broad remit and the legitimacy needed to offer that normative guidance. So although the title of the webinar refers to a global instrument, the notion of global is that it's the scope of the initiative that is global, so that the guidelines are available to all countries. And the final title of the initiative will be a matter for debate in the future once the conceptualization has matured. And finally, at a later stage, the idea is to develop more substantial guidance on the principles, including opportunities for their implementation at country level. Thank you. I will give back the floor to Mike now. Or actually to Stefano. Unmute yourself, Stefano. You need to unmute yourself. Yes.
Sure, thanks.
Thank you.
Thank you, Zaki. Thank you very much. Now, as Zaki, the previous presenter, mentioned and alluded to, now domestic laws and regulations are a foundational pillar of the governance of freshwater resources on the planet. Freshwater is an integral part of the wider natural environment where rivers, lakes, and aquifers form and flow in the water cycle. And it is closely tied to multiple sectors of economic and social activity and to the health of the natural environment. Now, the connection of freshwater to the other elements of the natural environment is particularly powerful in relation to land, including the subsoil, and the interactions that occur in nature or that are induced or influenced by man between land and water. So what I will be presenting is essentially a legal response to these interactions and to the need to regard and to consider water in this larger, broader framework. And I will essentially, my notes and my talk will essentially conjure up, if you like, a principle along the lines suggested by Zaki, mentioned by Zaki, a principle that I could define as one of legislative integration or coherence across the various regulatory domains that I will be illustrating in a minute. Now, traditionally, flood control has provided the space where the connection and interaction between land and too much water in this case is readily apparent and plays itself out, and where attempts can be detected in contemporary water legislation from a comparative perspective, and as alluded to by Zaki, to link the regulation of water resources development and use with land use and town and country planning regulation in particular. Now, significant space for interaction between land and water comes also from the natural groundwater recharge and discharge processes too, in particular, springs, wetlands, and oases, and from the influence that human activities above ground and underground have on these processes, including on the quality of groundwater. One need to think, as by way of exemplification, human activities like cultivation, animal rearing, afforestation, urban development, construction activities in general, mining, including coal seam gases extraction and fracking, tunneling, and the underground storage of wastes. Another connecting space is that of diffuse pollution, or otherwise termed non-point source pollution of water resources in general and of groundwater in particular, from land-based activities such as cropping and animal rearing, but also from urban development and stormwater runoff from polluted paved urban surfaces. Now, national legislation for the governance of water resources should be aware of and capture the complex web of interactions between water and land, including the subsoil, but also forests and the natural environment, and the multiple uses of water that sustain life, human health, well-being, and development across the full extent of the legal and regulatory spectrum of human actions that impact on freshwater or are impacted by freshwater volumes, flows, and quality. Now, at the opposite end of the regulatory spectrum, national legislation for the governance of land and the subsoil, forests, and the natural environment should equally be aware of and capture the same web of interactions and contribute, ideally, to the common purpose of safeguarding the Earth's freshwater from multiple source stress factors. Now, the pursuit of coherence and integration, which I am alluding to, horizontally across the legal and regulatory spectrum of human activities and actions that impact on freshwater or that are impacted by freshwater, requires and implies that domestic water laws and regulations be aligned and coordinated with other strands of the domestic legal and regulatory environment, ensuring consistency, coherence of direction and purpose across the domestic regulatory spectrum. Now, horizontal integration also requires and implies that the laws and regulations that make up the domestic legal and regulatory environment impacted upon and being impacted upon by water and rights to water, and I have in mind in particular, one need to think of legislation on land use and on the use of subsoil, including mining, legislation on agriculture, forestry, construction, building, environmental protection, that all this legislation to be aligned and coordinating in turn with domestic water laws and regulations. So two facets, if you like, of one and the same coin where water plays the central role. Now, some examples of what I'm alluding to. Now, horizontal integration is conceptually and practically quite a tough nut to crack, because for obvious reasons, regulation of the uses of the land and of the subsurface space escapes the scope of water legislation and is the province of town and country planning, construction and building legislation, mining, waste disposal, and you name it, you have it. So other strands of legislation. But the powerful connection of land and water tends to be lost on such legislation. Now, reconciling and harmonizing or just coordinating such legislation with mainstream water resources development use regulation and the relevant respective administrations, government administrations, is the challenge. For instance, the Flemish region of Belgium has responded to the challenge by linking water governance and regulation to town and country planning governance and regulation. In the specifics, water legislation adopted in the year 2007 seeks to integrate and harmonize freshwater development policy and regulation with town and country planning policy and regulation. This objective is pursued through the instrument of a water assessment, aiming to prevent, avoid, or mitigate the detrimental impact of town and country plans and of relevant administrative permit decisions on the water systems, surface and underground. Now, to this end, the water law prescribes a water assessment of certain projects. But because these projects are the province of separate town and country planning legislation, the concept of the water assessment instrument are mirrored in the town and country planning law, i.e. the Flemish Code on Spatial Planning that came on board on stream 2 years later in 2009. Now, this code, this law, prescribes that the water assessment mandated by the water legislation must be taken into account by the Spatial Planning Administration before a permit is granted under that law. So you see, through the one instrument of the water assessment featured in both sets of laws, the water legislation and the spatial planning legislation are made to work at the common purpose of safeguarding the health of freshwater systems from the threat posed by certain land-based activities. Another example that I can offer, it comes to mind, is California in the Sustainable Groundwater Management Act of 2014, where the same link is borne out of this land groundwater link is borne out of the option of a local agency or combination of local agencies overlying a groundwater basin and having land use, not water, but land use responsibilities within the basin to be eligible to become a groundwater sustainability agency for the administration of this Groundwater Act. So it's a very interesting concept where you see again land and water, working at a common purpose. The link is equally embedded in other provisions of the same statute, notably the direction that the recharge areas of groundwater basins under stress be mapped out, and that coordination be ensured with land use plans and land use planning agencies to assess activities that put groundwater, not land, but groundwater, quantity and quality at risk. Now, there are other provisions in the statute that bear out, the same concept, the same intimate link between land and water. But in conclusion, now, in response to the challenge posed by a multiplicity of laws and regulations and of government administrations that concur in sparse order to the makeup of the legislative, regulatory, and administration environment for the governance of freshwater domestically, coherence and integration of the domestic laws and regulations, and coordination among the administrative institutions responsible for administering and implementing the legislation are key to capturing the linkages and the multiple interactions of water and the other natural resources and elements of the environment, and to my mind, are highly desirable goals to achieve any country's policies and objectives within and outside the water sector. Thank you very much. Now, I'll give Mike, you have the floor.
Yeah, the floor. Thank you, Stefano, and thank you for that presentation. Sorry, I was kicked out by the software, so I'm back. Well, I will be presenting the last presentation of this group, and I will talk today about this principle of in dubio pro aqua. And my idea is to bring you some ideas about how to protect environmental flows by the judiciary. So first of all, what are the limitations of traditional water law? National water law has historically approached water primarily as a natural resource to be allocated among competing human interests. This traditional framework, however, has become increasingly inadequate in the face of climate change. While these laws effectively manage water distribution among different human uses, they largely overlook the ecosystem's capacity to sustainably provide water within the natural water cycle. So many countries continue to operate under outdated water use that reflect past societal needs rather than current realities. So for instance, some regions continue to prioritize hydroelectricity, even in areas experiencing permanent drought conditions, raising questions about the wisdom of diverting scarce water resources when alternative energy sources exist, for example. So what is the impact of climate change? So it has introduced unprecedented challenge to water management systems worldwide. So communities now face dual threats. So severe water scarcity in some regions and catastrophic floodings in others. A stark example is the Diana storm in Valencia, Spain, where the collision of hot and cold air masses resulted in a year's worth of rainfall in a single storm, causing 155 deaths, thousands of injuries, and massive economic damages. So one of the most serious impacts of climate variability that I can see from a water law perspective is on the security, dependability of water abstraction rights in general and relevant allocation. Okay, so this is a point being raised by Stefano, which I wanted to introduce in here. So local communities increasingly struggle to balance their basic human rights to water with economic activities. Indigenous communities face particular challenges maintaining the traditional water-related practices as water availability becomes less predictable. So now I would like to introduce the environmental law perspective on this case. So this environmental law emerged as a distinct legal discipline focused on ecological protection, clean water, as a fundamental component of the ecosystem. So this approach recognizes water's role in supporting both biotic and abiotic elements in nature. Okay, so it's very important. So from the environmental perspective, to bear in mind this water cycle where water begins with rainfall, pours into rivers and water bodies that provide a habitat and nutrient flow, then support aquatic life, sustain broader ecosystem elements like birds, riparian vegetation, and maintain soil health and groundwater systems. So I would argue in this case that the Brasilia Declaration of Judges on Water Justice, being issued in 2018, marked a significant step forward integrating water law and environmental law. So the declaration principle in dubio pro aqua, introduced by Chief Justice Antonio Benjamin of Brazil Supreme Court, states that in cases of uncertainty, courts should resolve water and environmental controversies in favor of protecting water resources and related ecosystems. So how do we implement from a judicial perspective this principle? The practical application requires a nuanced understanding based on environmental flows, defined by IUCN as the water regime provided within a river, wetland, and coastal zone to maintain ecosystems and their benefits where there are competing water uses and where flows are regulated. So this principle should not automatically prevent all water development projects, in my view. Instead, it should guide decision-making through a balanced consideration of, first, the essential flows needed to maintain ecosystem health. Second, human right to water access. Third, indigenous communities' traditional water uses. Fourth, ecosystem services benefits. And fifth, the nature of proposed water uses, essential versus non-essential. And we can introduce some other corrections like equity, like the gender balance perspective in solving cases. So a framework for modern water governance in this case is that the path forward requires using environmental flows as a baseline measure for implementing the dubio pro aqua. So this framework allows for nuanced decision-making that consider first the necessary water flow to maintain ecosystem health, protection of essential ecosystem services, fulfillment of human rights to water, preservation of traditional and indigenous water uses, and different standards for essential versus luxury water uses. So, for example, in case involving holiday homes versus indigenous communities' needs, the principle has helped prioritize essential uses while maintaining ecological balance. Similarly, infrastructure projects like dams might be permitted if they can be demonstrate compatibility within maintaining essential environmental flows and ecosystem services. So this modern approach to water governance recognizes that protecting governance and not just governance, but adjudication in the case that I'm pleading for, that protecting water resources require balancing ecological preservation with human needs, using scientific understanding of environmental flows as a guide for adjudication. So this is my presentation for today. Thank you very much. And now we have finished this first part of the presentation, and I will open the floor for Q&A if somebody wants to chat one more questions to the panel. Any questions? Apparently, and on the chat we don't have. Well, if no questions are out.
Sorry, Mike. There's one on the Q&A.
There is one.
Okay, I cannot see anything here.
It's from Claudia. Claudia, are you able to unmute yourself? If not, I can read this for you.
Oh, please do.
Okay. Claudia says, hello, thank you for your insightful presentations. I'm a researcher specializing in law and engineering. Yay. Focus on water reuse, governance, environmental justice. Fantastic. My questions. One, considering the rationale for a global normative instrument, how would such a global framework address the justice issues often overlooked in domestic water reuse policies, especially concerning marginalized communities? I can answer that right now by saying, hold on, Claudia, because my whole presentation will be focused exactly on that. So I welcome your input and feedback, but hold tight. There's going to be a presentation specifically on water tenure and particularly distributive justice and allocation issues under integrated water law. The second question is, how might the proposed global instrument balance providing global guidance while respecting the contextual diversity of freshwater governance at the local and regional levels?
Sure.
Excellent question. I will turn that over to the other panelists and then maybe add some thoughts.
Sure.
Fantastic. So, Stefano, would you like to?
Yes.
Yes,
sure. That is yes, I'm on. Very good question, Claudia. In fact, that is perhaps the how would I say, the key issue that comes into play when conceptualizing, advising on a revisitation, an assessment, a reframing, a reforming of water legislation. There can't be, for sure, there cannot be any off-the-shelf blueprint that one can use and simply change the name of the country and that's it. Absolutely not. And this is not what this initiative is all about. Absolutely not. However, this being said, there is a level of, abstract conceptualization that is driven by and informed by a wealth of experience on the ground, and which is reflected, in fact, in legislation, contemporary water legislation from across, a wide spectrum of countries that can actually be used and elevated to a reference, an authoritative source of reference, inspiration, and guidance for countries. So essentially, as this exercise and this initiative is trying to do, is to distill, if you like, from practice, from experience, from evidence, a number of principal concepts that guide and inform very much, and that one find a sort of common threads that run through much contemporary water legislation and provides that to the attention of countries. We feel that we will do a service while respecting absolutely the specific, circumstances, legal, constitutional, and otherwise of each and every country. So no notion and no idea, no intent to force a sort of a straitjacket of a blueprint, that would completely ignore the specific circumstances of each and every country. Absolutely, that's completely out of the question. But please, you fellow presenters, feel free to jump in, because this is a critical issue. This is a very critical issue that Claudia brought up.
thank you for that answer. Saki, would you like to pose a question?
No, I think I'm going to invite questions to be asked in the Q&A, and I see that one has just been added to the list. Shall I read it for everyone to?
Oh, please.
Would you like to go ahead, Mike?
No, please.
Okay.
No worries.
So it's a question from Kaula Zahwan. She asks, what types of subsidies or tax incentives are provided to farmers who adopt water-saving technologies or practices, and how effective are these measures in promoting water conservation? What types of subsidies or tax incentives are provided to farmers who adopt water-saving technologies or practices, and how effective are these measures in promoting? Oh, I think it's the same question more than once.
Repeated several times. Yeah.
Yeah.
Well, I mean, I don't want to, to monopolize the discussion here, but for sure, there's a range of, examples and experience from across the globe on this particular issue. So there is no, as I said, there is no straightforward answer to this and what works and what doesn't work. Surely it is one issue that is addressed, that ought to be addressed and is addressed and has been addressed in mainstream water legislation. For the moment, all that I can say is that I can direct, the person who posed that question to go and to the comparative analysis which are available, which are not very many, but comparative analysis of legislation. But this is more of an economic issue anyway. So you would have to look also for economic, literature on this particular issue. So again, no straightforward answer, but it's something that the mainstream water legislation should address, must address, in context with economic and financial instruments that promote the sound management, development, conservation, and use and governance of freshwater.
Okay, do we have another question? Oh, Claudia Sabelka she thanks for the answers, and she has a follow-up. What mechanism could be introduced to ensure policy coherence between water strategies and land use planning in regions where water scarcity drives only innovative technology-centric practices? Sure.
I can,
yeah, well,
I can take a crack at that one. I would say, again, you're jumping in and framing the discussion that's about to happen very beautifully for me. So I appreciate that so much, Claudia. But I would say there's so many different ways in which policy coherence has to happen between land and water. But I would particularly emphasize, as Stefano did from a planning perspective, the idea that we have sort of differentiated institutional, and we call them integrated planning, integrated land use planning, integrated catchment management planning, integrated, and then we have all of these different processes that are taking place under various pieces of legislation that then don't necessarily speak to each other. So I would say, as Stefano pointed out, having, sort of better ways to make those reflect each other within the legislation is essential. But I would also highlight, and I'll talk a lot more about this in just a moment, that this really begs the question of taking more of a water tenure lens to integration and looking at all of the various users and uses, whether legislatively recognized or not, and understanding the context within which we can start to ensure policy coherence in ways that are very specific within our existing laws. And I'll draw some attention to where there are overlaps that cause confusion across different sectoral laws in terms of ensuring equitable allocation and tenure security, particularly for those most vulnerable populations. But I think those are just a couple of ways. But you're sort of asking the $1 million question, right? Is that what are the ways that we do this well? And so I would really welcome other people in the audience to share experiences if they have them.
Thank you, Jessica. So I see that we don't have any more questions. So I will give the floor to Saki Schubert. She will convene the second part of this webinar. And the floor is yours, Saki.
Thank you very much, Mike. I'm delighted to be chairing this second part of the webinar and to introduce Jessica and Robin, who are going to give the next presentation. Jessica is a senior attorney and the director of the Environmental Law Institute's International Water Program. And she has over 25 years of experience on developing practical, equitable, and inclusive policy, legal, and institutional solutions to global water governance challenges. And Robin is the co-director of the Buchlerstein Consultants, a member of AIDA, a member of the IWRA, and she has extensive expertise in drafting national water laws and regulations. So I'm delighted to invite them both to talk to us. It will be a joint presentation about water tenure as a pillar of coherent, equitable, and accountable water governance. Jess and Robin, the floor is yours.
Thank you so much, Zaki. I'm going to share my screen. That is not working. Hold on. Stop share. You don't want to see my emails. You want to see the apologies. Let's see here. PowerPoint. Okay, are you seeing the PowerPoint now? Okay, great. Great. Thank you so much, Zaki. No, it's such a privilege to be here today, and thank you all for joining us. I will walk you through some of the work that my organization and our partners have been doing for the last almost decade now to look at water tenure, as Zaki said, as a pillar of coherent, equitable, and accountable water governance. And then I will welcome my colleague and dear friend, Robin Steen from South Africa, to talk about her extensive experience as one of the drafters of the South African Water Act in 1998, and then also someone who has been working on advising policy and legislation in the course of the practical implementation of this reform legislation over the last 20 plus years. So having that experience is really invaluable. Why water tenure? And I know this is for some people a relatively new concept, at least as applied to freshwater. So I wanted to quickly take a step back and provide a definition and just a brief overview of sort of why the tenure-related aspects of water governance can provide this critical entry point for achieving inclusive and sustainable governance, and as a lens for really identifying specific opportunities for more integrated and coherent water legislation and cross-sectoral legislation. So water tenure encompasses the relationships, whether legally or customarily defined, between people as individuals or groups with respect to water resources. So within water governance frameworks, water tenure systems include the rights and duties and the rules that govern those rights and duties that determine how individuals and communities are able to use various freshwater resources, for how long, under what circumstances, and how those rights holders relate to one another. And at the core of these water tenure systems are a bundle of rights that constitute the fundamental elements of these relationships between people and freshwater resources. So rights to use, manage, and develop water, among others, are created and protected by both legislative and customary frameworks, which may or may not be aligned. And importantly, many of these rights emanate not from water laws, but from a diverse cross-section of land, agricultural, constitutional, environmental, and other legislation that, taken together, often fail to provide a coherent approach to recognition and protection of water tenure rights. And this is particularly true for the rights of the 2.5 billion Indigenous peoples, Afro-descendants, and other local communities, and the women within those communities, who collectively and customarily steward approximately half the world's land, but only hold legal rights to about 10% of this land and its appurtenant water resources. So I'll really be focusing, while I'm taking a wider lens, a tenure lens, I'm going to be focusing specifically on the equity aspects and mostly talking about our work on the tenure rights of Indigenous peoples and local communities. The broad consensus that secure community land and other terrestrial resource tenure is a prerequisite for sustainable and equitable land governance and development has really been an incredible factor in strengthening the position of Indigenous and other rural communities in the political economy of land and forest governance. And it's had really tangible and positive results. Since 2002, there's been an increase in the global forest area owned by and designated for communities by 40%. Until relatively recently, however, the advocacy and policymaking processes around freshwater tenure rights has been a missing but critical aspect of this. So to fill this gap, actually, I think, oh yeah, I don't know why it didn't want that one to come up at first. A number of research and advocacy efforts are being and have been undertaken over the last 8 years or so to provide a more nuanced understanding of water tenure as a concept, to clearly define what the specific rights are that are most salient to freshwater security, and to unpack how water tenure relates to land, forest, and other resource tenure systems, both in law and in practice. And this work has really produced clear evidence of the critical importance of recognizing and protecting all legitimate tenure rights holders, and a pressing need for both communities and decision makers to have a much better understanding of how current systems interact across the various sectors that shape water allocation and use in ways that may or often are not equitable and sustainable. So this is some of the work and publications that my organization has done in partnership with the Food and Agriculture Organization of the United Nations. So I'll talk about that in a little bit more. And I saw my colleagues from FAO are online, and so happy to see them, with the International Water Management Institute and the Rights and Resources Initiative. If you're interested in any of these, please just contact me and I'm happy to share any and all. So the work that I'm just going to focus on very briefly today is the tenure tracking methodology that ELI and the Rights and Resources Initiative developed to define clearly the bundle of rights that are specifically held by Indigenous peoples, Afro-descendants, and local communities collectively as the basis of their water security, and to promote community livelihoods, cultural vitality, and sustainable development. So the findings that I'll quickly share are drawn from all of these countries. We did a 15-country study across 3 continents. And it also draws on some additional water tenure assessment work that we've been able to work on with the FAO under their assessment methodology, helping to develop and implement that across an additional 5 countries. So probably the first key finding, and not surprisingly, is that communities' freshwater rights are often dependent on their legally recognized land and forest rights. This is what we call the land-water nexus. Across the 15 countries we analyzed, was present in over 16% of the community water tenure regimes that we saw. And this is really significant for a number of reasons. First, the water tenure regimes that supported communities' water tenure rights under a land-water nexus, so that they came from a land law or a forest law or constitutional law on territorial rights, provided consistently better recognition of a wider range of community-based freshwater rights than water laws did. So the ability to realize a full suite of water tenure rights, for example, women's water governance rights, procedural safeguards to protect communities' water tenure, can't be adequately safeguarded if their land and forest rights are not also legally recognized and secure. And in some countries, the land-water nexus provides the only source of community-based water tenure rights. So water laws are really falling behind in terms of this. The diversity of laws that provide for the land-water nexus also highlights the critical need, and this comes back to Stefano's main point, for improved legal harmonization across sectors where those laws fail to speak to each other or can even contradict one another. Indeed, land and forest laws frequently mention water only in passing or implicitly, and water laws rarely speak directly to the legal status of communities' customary or collective water resource rights, and it failed to provide sufficient tenure security for the majority of rural users in many countries. So while the land-water nexus can provide more options for the recognition of water tenure rights, the contradictions or lack of clarity across laws can leave those legal rights open to challenge. Briefly talking about the critical aspect of customary water tenure. In many countries, the security of communities' land and water tenure rights really hinges on the interface between customary laws and government-issued laws that may or may not recognize those customary tenure practices as legally valid. So in the work we've been doing, and we've done some additional work, you can see this publication here that explores in the sub-Saharan African content, sort of the different legislative pathways for recognizing customary water tenure. It is on the uptick. It's happening. It's not happening mostly in water laws, though. It's mostly happening outside of water laws. So again, this land-water nexus is really crucial. There's rarely explicit recognition of customary water tenure in national legislation. So the implementation and protection of these customary rights really, again, hinges on the coherence across national laws and the willingness of administrations to apply implicit protection in favor of communities' water tenure rights. Not surprisingly, but not happily, probably the least recognized indicator that we had in our study, and continue to see this in additional countries, is for women's water tenure rights. And here we're really talking about women's specific water governance rights, rights to access decision-making, to have leadership positions, to have membership in decision-making institutions, or their water use rights. Less than a third of the community-based water tenure regimes that we saw had any reference to that at all, and only to water governance. Again, usually in the broader context of just natural resources and not specific to water. So this really highlights not only the need to really step up what we're doing in terms of water legislation and recognizing women's water tenure rights, but also highlights the importance of due process guarantees to prior notification, due process, access to justice, that provide the mechanisms for communities and women within those communities to protect their water tenure rights if they are being infringed. We're doing further work right now with the Rights and Resources Initiative to really unpack the legislative connections between women's water tenure rights, inheritance laws, marriage laws, and then looking very specifically at whether women have membership or leadership rights, and that should be out in the next couple of months. Finally, I just wanted to highlight that one of the biggest issues that faces communities in terms of realizing the full suite of water tenure rights is the suite of sort of administrative requirements that can be honestly an undue burden on them sometimes. While we did find that, you know, almost every country has a permit or licensing exemption for domestic uses, livelihoods uses often require some sort of incorporation as a user association, some sort of permit or licensing before they can be vested in communities. And this can be a real issue. This happened in about half, for livelihoods, it happened in about half of the community water tenure regimes that we saw. And this not only places often onerous financial and other burdens on communities, but also limits the duration of their water tenure rights. And other research has also clearly shown that many countries just lack the capacity to implement and oversee these permitting requirements in a way that actually reaches the vast majority of rural, small scale, particularly agricultural uses. So even where there may be appropriate levels of exemption, these are often not implemented in ways that are effective for rural communities. So broadly speaking, there's a strong need for innovative solutions to the gaps left by these compulsory permitting systems that aren't tailored to the needs and resources available to communities. And we're working on, you know, sort of looking at various ways to prioritize community use rights to strengthen their legal positions when conflicting claims arise, or expanding permitting classifications. Robin will talk a little bit about this in the context of South Africa in just a moment. So finally, just all of this work has resulted in the FAO has been spearheading sort of a political process within the UN system. The Committee on Food Security back in 2023 at the UN water meeting announced a global dialogue on water tenure to develop a set of non-binding principles for the responsible governance of water tenure. And the dialogue itself is really meant to be participatory, inclusive, global, at the regional and sub-regional levels, at the national levels. We're just kicking this off. And there are multiple opportunities to get involved, so please reach out if you're interested. So that concludes my presentation. Thank you so much for that. But here, I'll leave that up there for now, or no, I can stop sharing. And then I'll put Robin on the screen. So following on that sort of problematic setup, and thinking about the key issues related to water allocation, equity, gender issues in particular, we have, again, one of the main drafters of the South African Water Act, who's also been in the trenches learning the challenges and opportunities of its implementation over more than 2 decades. So we really have an incredible opportunity here to gain some experience from a very practical standpoint. We all, I think most of us water lawyers are very familiar with the South African Water Act as an incredible piece of legislation. That was purposefully tailored to the specific situation, the political and economic history of South Africa. And despite all of that, has faced some serious challenges in implementation. And so I welcome Robin Stein. Thank you so much for talking about your experience. I think you have to unmute yourself, Robin. And I have a couple of questions for you, but I welcome you to talk about whatever comes to mind. One thing that we've discussed as part of this group a lot as one of the foundational principles for water law is the public trust, treating water as a common good. And I wonder if you could kind of describe the role of the public trust doctrine in setting the foundation for equitable allocation and sustainable development under South Africa's water legislation.
Thank you, Jessica, and thank you, everybody. It's been a pleasure to listen to the presentations and, to pick up some very, very valuable inputs. The South African National Water Act of 1998 has been globally applauded as a landmark piece of legislation. It has also been acknowledged as a very practicable example of transformative legislation. And the reason why is because the National Water Act effected very radical changes in the context of access to water resources, use of water resources, conservation and development of those resources as well. In understanding the doctrine of public trust under the National Water Act, that is, Jess, you made the point earlier, and Stefano, you did too, in response to one of the questions. It must be understood that public trust under the South African legislation is a bespoke doctrine. It is a doctrine that was developed for South African circumstances. And that is, as you've said, Jess, because of the country's specific historical past. In the past, under the dire scourge of colonialism, the majority of people in this country were denied, effectively through legislation, of their access or right entitled to land. With that came entire dispossession of any access, use, right, and the like to water. The public trust, therefore, was brought in to enforce a sense of equitable access to water resources, while at the same time ensuring that sustainability was acknowledged as one of the Act's prioritized objectives. Under the public trust doctrine in the South African law, national government is established as the custodian of the nation's water resources. As such, water, wherever it occurs in the hydrological cycle in the country, is considered to be a resource common to all, harking back to the commons under the old Roman Dutch law precepts. It is essential to understand that there can be no right title or title to water. We refer under the National Water Act expressly as entitlements to water granted under a rather complex permitting process. The trustee has obligations to the nation's people and to give effect to the foundational pillars of the Act, and that is equitable access to water and at the same time ensuring environmental and ecological sustainability in the interests of present and future generations. Those two uses are prioritized together under the Act, not one above the other, but simultaneously through the concept of the reserve that is the quantity of water that is always held back, to ensure that there is enough water for consumptive human uses, but more particularly, because this is developmental legislation, for uses to improve human livelihoods, more particularly looking at marginal communities and those who do require historical redress because of the apartheid legislation and the effect of that legislation on rights. Does that give you a sense of what
Absolutely.
public trust does in our country?
Yes, yes, absolutely. Thank you. That was beautiful. And I love that you highlighted the role of the particular legal innovation of the reserve. And that kind of brings us right back to Mike's points around, looking at how to balance prioritization of ecosystem flows with the basic human needs or sustainable livelihoods needs and food security, and sort of what are the legal mechanisms that we have available to us. Go ahead, Robin. I can see you wanted to add something.
Well, I wanted to add something, Jess, to this conversation that we're developing. I mean, in addition to climate, which unfortunately is not expressly, I beg your pardon, mentioned in the National Water Act. So resilience and adaptation may need to be incorporated as another aspect or pillar of the reserve itself. I don't know whether you agree, but this is certainly a consideration that I do believe requires careful thought in any reform or amendment to the Act.
Absolutely. I would agree with that 100%. And I would say it really provides as well a mechanism for progressive realization of the human right to water as well in a domestic context.
But you raise a very important point, and this is the looking forward. We use the word redress of past racial and gender discrimination in the statute. But the looking forward approach is that which underpins the public trust document going forward. That is contained in South Africa's Bill of Rights. One must acknowledge that the Bill of Rights refers to water specifically in two places. Under the Property Rights Clause, which actually states that nothing can impede the state from taking land, water, and related reform. There's an Environmental Rights Clause, but water is specifically referenced in Section 27, together with food security, as a right. An enjoinder is in place on the state to take reasonable legislative and other measures to achieve that right.
So we really have a great opportunity to see a way in which, this sort of call for legislative coherence around water tenure in particular was enacted through these provisions in the Water Act, in terms of realizing the Bill of Rights through the specific sectoral legislation to achieve water tenure equity in theory. Now, I guess my next question would be, we've seen the struggles over the last 20 plus years to actually achieve this redress meaningfully. And I think one of the key things you and I have discussed around this was the lack of coherence between the land reform processes and the water reform processes in South Africa. Can you talk a little bit about that?
Well, precisely. I mean, that is probably one of the best examples where lack of coherence and integration rears its head and has very negative unintended consequences, no matter what the independent statutes, and there's a suite of them, are designed to achieve. The land reform project in South Africa, I'm going to deal with this very generally in the interest of time, because it'd be nice to have questions around this topic as well. But the general land reform project refers to or goes to looking at redistribution, land tenure, and land reform. Unfortunately, when the Act came into operation, it did not in any way integrate the land reform legislation into the reform project of the National Water Act. It is nowhere mentioned in the Act. And likewise in the land reform legislation, switched both ways, which has presented very disappointing outcomes, especially after 30 years of the democracy having rolled on. So the lack of crossing or cross-referencing and integrating policies, institutions between the two, may I call them sectors of legislation, really has created stress fractures, a number of stress fractures in terms of achieving the equitable access to water that the Act seeks to achieve and entrench. When land is redistributed and rights are acquired to land, given the fact that the National Water Act severed the right to land from the right to water, there's no riparian ownership in the National Water Act. It's all very well having acquired, a community having required land under a redistribution process. But with that land, there's no security of water tenure. And the community, or indeed an individual, is then set upon the licensing process, which is designed to prioritize redress, but does not, in fact, provide a user-friendly model in the implementation. That is, if the general blanket of the general licensing blanket that we call a general authorization is not in place. So there lies an unintended consequence brought about by stress fracturing because of the lack of cohesion between the two projects and the legislation that underpin them. And I do believe that there is an urgent need to address this in the legislation. Integration across the sectors, but land and water, the reform processes need to be co-joined.
Thank you so much for that, Robin. I think in just the answer to those two major questions, you've touched on so many different aspects of sort of the core elements of what we're talking about when we discuss legislative coherence in the South African context. So thank you. I don't want to cut you short, and I definitely want to give you more time to respond, but I'd like to also open up. I see we have some questions in the Q&A waiting to be answered. And I don't know if others want to type their questions in, but I want to give the participants a chance to chat with us.
That'll be wonderful.
Zaki, I'll turn it over to you as the moderator.
Thank you, Jess, and thanks a lot to you and to Robin for a fascinating presentation and dialogue. And we have a few questions, and I'll start with the first one, which I'll read on behalf of Catherine Guazdon. Water rights on tribal lands is a big issue in the US now. Courts are now reinterpreting treaties to not include water rights in previously agreed upon interpretations of life that included water/water access. And she gives the example of the US Supreme Court, Arizona versus Navajo Nation. This is a troubling rejection of precedent and an attack on the supremacy of treaties. If courts are not an avenue to defend Indigenous water rights, or is there an administration hostile to any notion of water rights or Indigenous lives? What advice can we give to tribal members?
I think that one was probably for me, but I'm happy to have anybody step in and give their thoughts on this. I mean, yeah, it's very troubling indeed, because one of the things that we really rely on, and we have a fabulous judge on the panel today who might give his thoughts to this as well, but that we rely on the courts to really, to interpret, enforce, and respect and protect the rights of the most vulnerable, and that this is a very, among several concerning trends in the US related to water, I'll say, related to water. So I think one of the things that we would need to focus on, and not really, I'm in no way trying to plug our Judicial Education Institute, but we do need to educate judges. That's part of what, and I think another question was that Claudio raised below on the challenge that communities have that are unaware of their water scarcity issues and don't really advocate their rights or voice their concerns. I think, you know, this is all a piece of the bigger picture of, we can work on having this guidance for countries, but another critical aspect of this is legal empowerment, right? And legal empowerment of communities to really understand what their rights are and how they can advocate for them, and to understand the context, why it's, I've last 7 years, I lived in Zimbabwe and worked with rural communities in Zimbabwe on these issues. And you know, there was a lot of misunderstandings and conflicts that are coming up around people really thinking other communities are taking more water, when in fact, you know, as you said, it's ongoing persistent drought or other factors coming up. But having that kind of legal empowerment where people are aware of their rights, able to advocate for them, connected to civil society organizations that can advocate on their behalf in the courts, and then judicial training. So that judges and prosecutors both are capable of understanding these concepts and implementing and enforcing them effectively and appropriately is really critical. I know that's not a great answer for, you know, sort of how to give advice to tribal members, but I would invite you to talk with me a bit offline, because we're working with the Indigenous Women's Leadership Network and others on some of these issues to try to see how we can advocate for better recognition of treaty rights and other non-treaty rights. But please, I don't know, Mike, or if anyone else wanted to add to that.
Robin has her hand raised, so I'll give her the floor, and maybe Mike after that.
Just very briefly, it's one of my bugbears, and I do believe that the A for accountability actually does also prevail in these circumstances. And accountability, the principle of accountability, does have a number of legs, one of which I do believe should be information sharing, the right of access to information, and insisting on monitoring and access thereafter, open access, that is. This is a very touchy area, particularly in this country, because that information is oftentimes highly technocratic. And once again, we need to rethink accountability in this context. How are we going to think through what real access to information is, and then recourse thereafter? Where does recourse lie? What is the forum? Can we create more effective participatory forum or fora?
Well, thank you to Katie. Well, she's a member of the WCL, and she raised always very, very interesting questions. In this regard, I will step into what Jessica and Robin said. I will support everything that they said, and I will mention that we as lawyers, we have a social trust upon us in terms of fighting for the rights of the people. So I would say that we cannot take this interpretation by the U.S. Supreme Court as the loss of the battle, but probably a setback. But still, we need to play hard in terms of trying to protect the rights of the people, building up the information, as Robin mentioned, and as well the work with communities and pressure that they might bring forward in terms of clarify that water needs to be understood as a life, associated with life, as many Supreme Courts have endorsed that connection, particularly the Indian Supreme Court. So I would keep going on, Katie. I know that you have a lot of stamina on this regard, so keep going.
Thanks for your answers. There's another question from Katie as well, which I'll read out. The US State Department has consistently told IUCN US members that we need to make stronger connections between our conservation issues with security issues to get the attention and support of nations. In the Army War College report on climate change of 2019, water is mentioned as a security issue for force readiness, but also related to increased conflict and refugees. Are there any resources or IUCN actions specific to water/security? This could be a powerful motion for the upcoming IUCN Congress. Jess and Mike, your hands are up. I saw Jess's hand first, so I'll give you the floor first. Go ahead.
Just very briefly, so ELI is the sort of institutional home for the Environmental Peacebuilding Association, and we've done a lot of work making those linkages, specifically in the context of both sort of during armed conflict and then peace building before, during, and after in conflict-affected environments, the role of water governance and water law. So I'm happy to share those resources and would encourage you to join the Environmental Peacebuilding Platform, which is an incredible resource. And yes, I think that we could easily articulate the clear linkages, particularly between water tenure and managing conflict, as well as how do we define water security in a changing climate, and what does that mean for water tenure security of the most vulnerable? I think there are so many, when you look at the movement of populations, and you look at sort of balancing humanitarian provision of services with water rights under national law, there are a lot of open questions that we're still grappling with in terms of how best to manage this. So yeah, that would be my recommendation, and excited to see that as a priority.
Mike.
Yeah, thank you, Saki. Katie, the environmental law program of IUCN, based in Bonn, in Germany, has been working along the Organization for Security for Europe for a long time. And I took part in two pieces of research in terms of security and water. So I would encourage you to contact Alejandro Isa, the director. He's a very nice chap, and probably you can make a very good source for what you are bringing forward. That's it.
Thank you, Mike. We do have Claudia's question, just you partly, or you answered it, but I might still read it again in case anyone else would like to add to what Jess has already said. And she says, how can governance frameworks address the challenge of communities that are unaware of water scarcity issues and as a result do not advocate for their rights or voice concerns, particularly in contexts where water reuse policies might disproportionately affect them, especially in cases where government does not act effectively? Robin, did you raise your hand? You're muted. Robin, you're muted. We can't hear you.
Jess, I think this is something, can we both take this question together?
Unmuted.
You go first.
Please.
Yeah.
No, I've already, I feel like I've already sort of spoken a little bit about the absolute critical importance of building in legal empowerment and capacity building around as part of water governance initiatives. That, it's been a privilege for me to be able to work at that level, at the community level, and actually do capacity building on water tenure rights and natural resource tenure rights, and see the change in terms of what communities are able to do, mobilize and make actionable once they understand what those rights are clearly, and also have the resources, are connected to the lawyers, to the civil society organizations that can advocate on their behalf. So yeah, I'll turn it over to you for more, please.
I just wanted to mention again, looking at some of the stress fractures that have emerged over time in the implementation of the National Water Act. And that is the incoherence between institutions and the implementation of the law, the very uneven implementation of the law by these various institutions. But coming back to a central feature of the National Water Act, which does provide something of a good lesson, hard learned, and that is the decentralization that the Act actually aims to achieve, the governance of water at the lowest, most appropriate level. Now, despite the project of establishing catchment management agencies throughout the country within a reasonable period of time, since 1998, we have only 9 operational catchment management agencies. The representation of those agencies is unfortunately not what was intended in the first place. And I think that, again, comes back to my concern about accountability and oversight. I do firmly believe that equitable access and water tenure, secure water tenure, does depend on a high level of participation, effective participation, and a system, an institutional arrangement that does integrate multi-sectorally, not just individually. And so important, again, in the land and water reform processes as they develop out in our country. So when we talk about legislative incoherence, we should also consider, from a governance perspective, how do we achieve innovative ways to achieve integration, to achieve equitable access, secure water tenure, sustainability and its goals through institutions that are able to work together, manage together, and at the end of the day will stand the test of accountability.
Thank you, Robin. Thank you, Jess, as well for answering Claudia's question. We have a couple of minutes left. If there are any burning questions, please ask them now. But I have a notification that there are no open questions anymore. So I think I'm going to invite Stefano to say a few concluding words. Stefano, the floor is yours.
Thank you, Zaki. And thank you, of course, to the presenters. We've heard and we've listened to some very thought-provoking presentations. We have taken very, just as thought-provoking questions as well, which actually will enrich definitely the further process that lies ahead. I should emphasize perhaps once again that this initiative is not about generating a new overarching international pact or convention of sorts. It's just to, as I say, as has been said at the start, to conceptualize a framework of principles, of guiding principles, which surely will be enriched by the debate that has taken place in this webinar. This is not the end of the story. It's only the beginning of a story. And we expect, further rounds of consultations down the road as the conceptualization process unfolds and develops in the months to come. Thanks to all the participants, thanks to the presenters, and I guess, is it up to me to close, to declare the seminar closed or the webinar closed?
Yes.
Or, okay, you can see the point. All right, so we can then call this webinar to an end with many thanks again to all the participants and to the presenters. So until the next time, until the next iteration. Okay, goodbye now to everybody.
Stefano, may I thank Roberto for his help?
Please,
Oh,
please,
yeah.
There
yes,
is
yes.
Roberto from WCL Secretary. Thank you,
Yeah, in
Roberto.
fact, perhaps I have limited authority to call it to an end. But I was wondering, is it up to me or what?
No worries. Okay, bye now.
Thank you.
Okay, thank you.
Thanks.
Thanks, everybody.
Bye-bye.
Bye-bye.